Welcome to this special episode of the Rabbit Hole Cafe, where we explore complex questions hidden beneath everyday systems. Today's focus: Quebec's rent law, the rights it protects, and the burdens it might unintentionally create. It might surprise you to learn that in Quebec, a tenant can simply refuse a rent increase, just say no, and legally remain in their home under the old conditions. Now, on the surface, this sounds like, well, a truly powerful protection. A really robust shield against sudden, unexpected rent hikes may be designed to ensure affordability, especially in a housing market that often feels incredibly challenging.
That's definitely the immediate take, yes. And it really highlights the law's compassionate intention, you could say. But as you dig a bit deeper, a really fascinating paradox starts to emerge. What happens when that fundamental right to stay, to effectively freeze your living costs, crashes head on with someone else's equally valid right to, well, start fresh? Think about a young family maybe hoping to buy their first home, or perhaps a new investor just trying to make things work financially. This isn't just theory, it creates a very real pressure point, not just for landlords, but for aspiring homeowners too, and you could argue for the whole housing system itself. So our mission today really is to unpack the legal roots of this unique law, look at the human cost, the systemic cost it can impose, and ultimately ask whether our solutions are keeping pace with today's reality, or if we're maybe still relying on tools built for a different time.
Okay, let's get into the mechanics then. How does this whole automatic renewal and refusal thing actually play out? Because in Quebec, residential leases, they automatically renew. That's key, right? A fixed-term lease doesn't just end. It transitions maybe month to month or another fixed term, and critically, it keeps the exact same conditions as before, unless, of course, proper formal notice is given.
That's a really crucial point. If a landlord wants to bring in a rent increase or change any other lease condition for that matter, they have to follow very strict rules. They need to send a written notice to the tenant. Usually it's 3 to 6 months before the current lease ends, depends a bit on the lease length. And this notice, it's not just about the new rent number. It has to clearly lay out any other adjustments, things like parking, pets, maybe even which utilities are included or not.
Right, so once that notice arrives, the tenant basically has three paths forward. They can accept the new terms, signal agreement, simple enough. Or they can refuse those new conditions but choose to stay in the apartment. Or option three, they decide to move out when the current lease is up.
And here's where it gets really interesting, where the dynamic truly shifts. If the tenant chooses option two, refuses the increase, but wants to stay, that immediately kicks off a specific legal procedure. The landlord then really has no choice but to apply to the Tribunal Administratif du Logement. Let's call it the tail. It's easier. The tail is the official body that reviews these things, approves or rejects the increases. But, and this is important, the tail doesn't just rubber stamp requests. Oh no. They do a pretty thorough evaluation. They look at the landlord's operating costs, maintenance, property taxes, and crucially, they compare the proposed rent to similar places nearby. The goal, on paper, is fairness. But here's the kicker, the real challenge. Until the tail actually makes a decision, the tenant just keeps paying the old rent. And because of huge backlogs at the tail, the status quo can last, well, not just months, often over a year. So what starts as a temporary safeguard can become a very long-term freeze on rental income. It really changes the game.
It sounds like the original idea, the intent behind it all, is genuinely quite noble. Prevent people from being strong-armed, ensure tenants aren't just forced out because they can't immediately agree to a new rent. That ability to stay put while things get sorted out, in principle, that feels very humane.
It is, in principle, absolutely. However, this very protection, it can create some specific, maybe unforeseen challenges. In practice, the tribunal is just, it's swamped, overwhelmed. We're talking cases often taking over a year to resolve. And through that whole time, remember, the tenant stays paying the original rent. Now, this creates a powerful kind of leverage for the tenant, doesn't it? It's not always about whether the proposed rent increase is actually unfair or not. Sometimes it's just the sheer length, the burden of the process itself that becomes the shield. So in some cases, tenants who are aware of these delays might, well, strategically use them. They might refuse even pretty modest increases, knowing the cost, the time, the hassle of proving the case. It all falls onto the landlord. This dynamic really shifts the burden of proof, the risk, onto one side.
And the strain isn't just legal or financial, is it? It must go deeper. Psychological strain, too. Imagine you're a landlord. Maybe just someone with one or two units, not a big company. You're facing rising taxes, maintenance bills, maybe your mortgage rate just went up. And under this system, you might be stuck, unable to adjust your income from that property for a year, maybe longer. And what if the case gets dismissed or contested? Does the cycle just repeat? That uncertainty, it must be incredibly draining.
Exactly. And when you connect these individual stories, these struggles, you start to see a bigger picture. What was genuinely designed to prevent harm, to protect the vulnerable, can sometimes, in certain situations, become its own kind of pressure point. It creates new difficulties for others in the system.
Okay, let's look at a specific scenario that really highlights this pressure point. You mentioned the new homeowner's dilemma. We're not necessarily talking about big corporations here, are we? Often it's individuals, families. Maybe a young couple buying their first place could be a recent immigrant, someone who's saved up to buy a duplex or small triplex. And the plan is to live in one of the units themselves.
Yes. And their situation can be really stark. They might close on the property, sign all the papers without fully realizing that a tenant already living in one of the units has this legal right. The right to refuse a rent increase or maybe even refuse changes needed for the owner to move in and simply stay put. This right continues even if the new owner explicitly bought the place intending to live in that specific unit. Sometimes the tenant might not even plan to stay long term. But just by exercising that right to refuse the new terms, freezing the old lease, they trigger the whole TAL process. And that delay can effectively block the new owner from accessing their own home.
I remember hearing an anecdote about this. It really stuck with me. A new buyer in Quebec bought a property, only to find out just before closing the tenant had refused a pretty modest rent adjustment. The buyer's plan was clear. Move into that unit. That was the whole point of buying it. But because the tribunal delays were so long, the tenant ended up staying. Not for weeks, but for over a year. The buyer was, understandably, beside themselves. Apparently, they even called the police at one point. And the response, straight up, sorry, it's a civil issue, meaning it's between you and the tenant, not a criminal matter. You have to wait for the tribunal. No eviction order, no hearing date anytime soon. Just the old lease, legally ticking along.
And that brings us right to the huge practical problems. Imagine the financial strain. The new owner is paying the mortgage, insurance, property taxes, all in a unit they can't live in, can't even renovate. And with the TEL backlog being what it is, sometimes even growing, these owners are left completely in the dark. No clear idea when their case will even be heard, let alone resolved, or basically trapped, indefinite limbo.
So a law intended as a shield for the tenant becomes, well, it freezes the new owner's life in place. A procedural delay turns into denial of access to your own property. A regulation meant to help one party unintentionally traps another. Wow. And the fallout from this, it really goes beyond just these individual situations. It creates ripples, systemic effects. Just think about the burden on the Tribunal Administratif du logement itself. The Tele. Every year, they're handling tens of thousands of disputes. Rent issues, lease renewals, repossession hearings, you name it. At any given time, there are something like 27,000 applications just sitting there, pending in their system.
27,000, that's huge. And the delays we talked about. For general rent-setting cases, the average wait used to be around 14 months. You're saying it's down slightly now, maybe 10 months. Still, that's almost a full year. A year of legal limbo, financial uncertainty for everyone involved. Exactly. And then there's the clear economic cost. For tenants, going to the tribunal is designed to be fairly low cost, accessible, but for landlords, especially these new homeowners who might have just stretched themselves financially to buy the place, the costs can be really severe. You've got lawyer fees, potentially, the loss of rental income they might have otherwise received at market rates, plus the constant pressure of mortgage payments. An average tribunal hearing, when you factor in the waiting time, effectively costs the owner 10 to 15 months of expenses on a property they might not be getting full or any benefit from.
And beyond the legal side, the money side, there's this other cost you mentioned, social trust. When a law feels like it's heavily tilted one way, protecting one group but maybe at a significant cost to another, that's bound to create some resentment, right?
Yeah.
And it's probably not just landlords versus tenant. It could spill over, create friction between renters and owners generally, maybe young versus old, newcomers versus established residents.
I think that's a very real consequence. And let's be absolutely clear here. Robust tenant protections are vital. They're essential for a just society. No one is disputing that. But it forces us to ask a tough question. Can we genuinely call a law fair when the cost of implementing that fairness, the burden, is loaded so heavily onto someone else? Is that balance?
This really brings us to that idea you touched on earlier, laws as a kind of social technology. We create them like tools, right, to manage things, prevent harm, protect people. But like any tech, laws can get old. They can outlive the specific problems they were built to solve. And sometimes, in doing that, they accidentally create new problems. Problems are maybe slow to even see, let alone fix.
That's a really insightful way to put it. Quebec's rental laws, they came out of a specific time, a period of real hardship. They were a direct answer to an era of, sudden evictions, crazy rent hikes, clear power imbalances where tenants often had very little recourse. The main goal back then was basic housing security, stability.
But fast forward decades later, and we're applying that same basic logic, that same tool, to a world that looks quite different. Today, the imbalance isn't just economic, maybe. It's also procedural, as you described. A tenant can refuse, no reason needed up front. But the landlord, they have to carry the full weight, legal costs, financial stress, emotional burden of proving their case, often for over a year, with no guarantee.
And what's really fascinating, maybe even a bit strange, is how reluctant we seem to be as a society to even question it sometimes. Why do we treat certain laws almost like sacred common sense, even when they kind of clash with principles we apply everywhere else? I mean, think about it. We accept that costs for almost everything else go up over time. Food, car repairs. You don't walk into a grocery store demanding last year's price for yogurt just because, that's what you budgeted for. We generally get that when costs rise for the provider, prices rise for the consumer. Yet when it comes to housing, arguably the biggest, most capital-intensive service someone might offer or receive, we've carved out this major exception. And we've written that exception right into the law.
So is that just compassion? Pure and simple? Or is it maybe inertia, like societal habit? A resistance to changing something that's been around a long time? Are we really evolving how we think about fairness in this area? Or are we maybe accidentally protecting yesterday's idea of justice, even if it creates unfairness in today's world?
It really forces a difficult reflection, doesn't it? The law, as it stands, it doesn't really ask, okay, what's a reasonable increase here? What's sustainable for both the owner and the tenant long term? Or maybe most importantly, who else might be getting hurt while we're preserving this specific right in this specific way? It just maintains the rule. And often just maintaining that rule is presented as if that by itself is balance.
So, wrapping this up, Quebec's rent law. It clearly came from a good place meant to protect people born from compassion, from wanting a society where people aren't just tossed aside when costs go up, but protection if we don't regularly check if it's still working as intended, if we don't evaluate it. Well, it can become blind policy, can it?
Precisely. A right that was once a powerful shield for the vulnerable can, over decades, morph into something else. A lever that puts a disproportionate burden on others. We've seen how that plays out. Tenants needing no reason to refuse, landlords facing huge strain, new homeowners literally locked out of their own homes, and a tribunal system drowning in cases it can't possibly process efficiently.
And still, we often call it fair. Still, sometimes treat it like obvious common sense. But fairness. Fairness isn't a fixed point, is it? It has to evolve, just like society does. Our systems of justice need to evolve too.
Right. If we genuinely want a society that protects all its people, not just some at the expense of others, we have to start asking better, maybe harder questions. Not just, what does this law protect? That's important, but also, whom does it burden? And how is that burden shared? Can we actually design laws that are more adaptable, that can respond to changing times? Laws that protect without paralyzing. Rights that are flexible enough to see the context, not just apply a rigid rule. Because ultimately, justice isn't just about defending how things were done in the past. It's about actively creating something better, fairer than what we inherited. And that takes more than just good intentions. It takes real courage, the courage to question, to refine, maybe even to rebuild.
Thanks for listening to the Rabbit Hole Cafe. If this episode sparked questions, thoughts, or reflections, share it with someone who cares about housing justice and stay curious.